Hello there. As a follow-up to my video I've just uploaded, I've decided to do it on a case-by-case basis, so it makes it easier for me and probably easier for you too. So let's begin. I think the first case, the most important case to start off with when we examine the historical development of the duty of care is the case of Donoghue and Stevenson of 1932. The facts are very well known, but for those who don't know, it follows this kind of story. Donoghue and her friend, they were travelling to a cafe in Paisley in Scotland, and upon arrival, Donoghue's friend bought her a drink and herself a drink. Donoghue asked for a bottle of ginger beer. Now this was in an opaque bottle. Upon drinking the beer, Donoghue was very shocked to find out that once she poured the remainder of the beer into her glass, out popped a decomposed snail. She was, as you can imagine, it wasn't too nice. And a few hours later, Donoghue complained of bad stomach pains, and her doctor later diagnosed her with gastroenteritis. And also, as a result of the gastroenteritis and seeing the actual snail pop out into the glass, she apparently suffered from nervous shock, which today is known as psychiatric injury. Now, at first instance, Donoghue was not able to claim under the law of contract because she was not privy to the contract, the original contract between Stevenson, the defendant, and the other party, which is Donoghue's friend. Now, if she had bought the drink, it would have been different, but she didn't, so there was no claim under contract. However, following the case of Heaven and Pender, Lord Esher stated that there were certain elements that gave rise to a negligence principle. So Donoghue found that she was able to claim for her injury, which is the gastroenteritis and the nervous shock. This was settled out of court, and I believe she received around £5,000 in damages, which at the time was a substantial amount of money. Now, this set a very, very big precedent in the tort of negligence. It was pretty non-existent before that case, really. But the famous jurist, Lord Aitken, developed his neighbour principle, and in his narrow ratio, the ratio decidendi, it was held that the manufacturer owes a duty of care to the ultimate consumer. And further in his ratio, he said you must take reasonable care to avoid acts or omissions that you can reasonably foresee would be likely to injure your neighbour. So essentially, that's the neighbour principle, and it has kind of a biblical tone to it. And he went on to say, who was your neighbour? And it was something along the lines of anyone who was closely or directly affected by your actions. These would be deemed to be your neighbour. So essentially, this created the tort of negligence. Well, it didn't create, but it helped develop the tort of negligence, and established that there was a duty of care where there was proximity between one party and another, this being the injured party and the defendant. So in essence, this case establishes that there were duty of care in certain situations. However, also in this case, there were rise to a few questions that questioned Lord Atkin's neighbour principle. The first being, well, the only one being actually, was it really only established what ought to be if there wasn't a duty of care in the first place. So again, we have the problem of uncertainty, which is a kind of a running theme throughout common law. Because when we have individual judges applying their discretion, you're going to get cases where there are going to be differing opinions. So therefore, it's going to be hard to advise your clients on whether there will be a duty of care implied by the court or not. So essentially, this is the foundation case, if you like, to the duty of care. And when answering a question in relation to the historical development of this duty of care, this should always be the one to start off with. I do recommend mentioning Heaven and Pender as well. Unfortunately, I don't have the facts of the case, but I do know that it was Lord Esher, formerly Lord Brett, Master of the Rolls, in 1883. It would give rise to a negligence principle. Okay, thank you.